Good morning, everyone. Thank you for all of those of you who have attended here in person today, and welcome to everyone who's joining us probably in their pyjamas at home watching this webinar. My name's Paolo Tatti. I'm one of the principals here at Aitken Partners. I practice in litigation and insolvency, but where I can, I also practice in defamation. Some of you might remember 2 years ago, about this time, we ran our first update on defamation. It was one of our very first online webinars, right smack bang during COVID. And in the 2 years that's followed, things have changed quite significantly. In particular, as we all know, in this day and age of technology, it's very easy for people to jump on their smartphones when they're out and about and make that post online about a business or a service. We see it all the time in hospitality, we see it all the time in all sorts of places. And the very real question is, well, what can you do about that nasty customer or that nasty consumer or even that nasty person that has never actually met you, has never actually purchased your goods, purchased your services, yet takes to the internet to blast you? Over the last 2 years, the High Court, which is the highest court in this country, has weighed in on defamation twice. Now, that's pretty rare. The High Court generally takes on about 40 to 50 cases Australia-wide a year. And yet 2 matters have caught their attention, and notwithstanding the reforms that we've seen to the defamation law, they have really broadened the scope of what is and is not defamation, particularly in relation to publishers. So what we're going to do this morning is I'm going to invite our first speaker, Amanda Robinson, who's a lawyer with Aitken Partners, to come up and just remind us all a little bit about defamation, what it's about, the elements that need to be proved, and she'll also touch on the first of the High Court's decisions in a case called Voller. We'll then have Melissa Marcus, who's a very experienced barrister, and I'll introduce her after Amanda, and she's going to talk to us about a really interesting case, which is the second one the High Court has weighed in on, which is Defteros. And after they've shared their thoughts on those, I'm going to get up and I'm going to tell you what it all means. What does it mean to your business? What does it mean to you as individuals? What can you do? What should you be doing? And we'll also touch very briefly on some further reforms which may come in the near future. So without further ado, I'll invite our first speaker up. Amanda Robinson has been with Aitken Partners for, I think, about 4 or 5 years now. She started her journey as a law clerk here, proceeded to do her traineeship, her grad year with us, and has become a full-blown lawyer. Amanda, like me, really enjoys working on defamation matters, and where possible, we love working together on these things. So please welcome Amanda to tell us a bit about Defo.
Morning, everyone. Thank you for coming. I appreciate mornings are a little difficult, even in the corporate world. I know I certainly don't like them. Don't tell my boss. All right, so my name is Amanda, and I'm a lawyer here at Aitken Partners. Now, I'd like to begin by providing an overview on what defamation looks like, for those who perhaps didn't join us in the 2020 defamation seminar. All right, so back in 2005, the Australian states and territories first passed legislation to enact the model defamation provisions. So these essentially created uniform defamation laws throughout Australia, bringing an end to the issues that divergence between jurisdictions would cause. So then in or around 2019, the states and territories reviewed these provisions and agreed to changes known as the Model Defamation Amendment Provisions 2020. These were then divided into 2 stages. Now, as some of you will be aware, the Stage 1 amendments came into force as of 1 July 2021 in Victoria, New South Wales, South Australia and Queensland, with other states to follow. Now, these amendments sought to bring the legislation in line with the digital and technological advances that relate to how people communicate, social media and online news reporting. We unfortunately don't have enough time to really go into all the 2021 amendments in any great detail, but some examples of these amendments include the new serious harm element, public interest offence, and the single publication rule. Now, I note the Stage 2 reforms are currently in the wings, and Paolo will touch on this a little bit later. These relate to liability for publication of third-party content, which is important given the recent case laws, which Mel and I will discuss shortly. So the purpose of defamation law is to strike a balance between protecting a person's reputation and not placing unreasonable limits on the freedom of expression. A cause of action arises for defamation when a person suffers harm by way of damage to his or her reputation by the publication of defamatory matter to a third party. Note that in Australia there's no distinction between libel and slander. So, for this cause of action to arise, a series of thresholds must be met. The first of which being publication. Publication is the act of communicating defamatory matter to a person other than the plaintiff. The communication can be either written, spoken, an image, so on. So any person who voluntarily participates in the dissemination of defamatory matter is considered a publisher. What is considered voluntary or even participation in these novel contexts presented by the internet, as we've seen in both Voller and the Defteros decisions, is quite broad. So while most defamation matters involve positive conduct on the part of the defendant, liability doesn't actually require that the defendant engage in a positive act of publication. So we'll expand on this shortly. The second element I'd like to touch on is identification. So the communication needs to identify the person who is claiming to be defamed. This requires that the plaintiff establish that the defamatory matter was published either of and concerning the plaintiff or reasonably referable to the plaintiff. So this can be done one of two ways, either direct identification or indirect identification. Now, as the name suggests, direct identification is relatively straightforward. This is done by either referring to someone directly by name, or alternatively by referring to someone by some other means which the ordinary reasonable person would be able to identify them by. For example, title like Prime Minister. Although there was that stage in recently when no one actually knew who the Prime Minister was because we kept on swapping every now and then. The second one is indirect identification, and this is a little more complicated because it requires additional knowledge that allows that third party to identify the plaintiff and that at least one person with that special knowledge received the publication. For example, the person that lives at 140 William Street. If someone knows the person that lives there, that plaintiff can be indirectly identified. But there are issues with indirect identification in this regard because what if 140 William Street is actually a share house of 30 students? So unless that publication said all people that live at 140 William Street, insert defamatory statement here, the plaintiff claiming to be indirectly identified isn't personally pointed to by the words. So there's that difference. The third element is defamatory meaning. Defamation is concerned with meanings conveyed by a publication, known as imputations. An imputation is any statement about a person which asserts or attributes an act or condition to that person and includes not only natural and ordinary meanings, but also true innuendos. So there are two types of meanings that can arise here. The most straightforward being the natural ordinary meaning. The natural ordinary meaning of a publication is the meaning which the publication would convey to the ordinary reasonable person. And this is comprised of the literal words themselves and any implications, inferences, or indirect meaning that might arise from the same. The second is true innuendo. So this is where an imputation is published to a person with special knowledge, and such knowledge may transform what is otherwise an innocent publication into one which is defamatory. I've been asked to include examples, so bear with me as I try not to defame anyone on Zoom. So an example of a true innuendo would be the statement, Paolo enjoys frequenting King Street. Now, this could mean to the ordinary reasonable person that Paolo simply likes taking long, meaningful walks on King Street. Alternatively, if the ordinary reasonable person has special knowledge that King Street was an incredibly popular place of employment for hard-working, well, you get the gist, or maybe not, but that's the point. To succeed on a cause of action based on true innuendo, the plaintiff must prove that at least one recipient of the publication had knowledge of special facts as at that time of publication. Now, depending on what imputations arise from the natural ordinary meaning or true innuendo, For a publication to be defamatory, it must also be capable of either lowering the plaintiff in the eyes of society generally, 2, leading others to shun or avoid the plaintiff, or 3, exposing the plaintiff to a not trivial degree of ridicule. This doesn't mean, though, that just because the publication may lower you in the eyes of others, that you've actually suffered any harm. As such, there's one final element that I'd like to touch on, which, as I briefly mentioned earlier, came about as the 2021 amendments. Now, this is the serious harm element. Now, this requires plaintiffs to establish that the publication is caused or is likely to cause serious harm to their reputation. The purpose of this reform was to prevent trivial claims from the outset, and some important matters to note about this element is that serious harm is to be determined by reference to the actual facts about the impact, not merely the meaning of the words. The plaintiff must prove on balance what the harm was caused by the defamatory publication, whether it was or will be serious. Damage is now no longer presumed, and it's to be decided by a judicial officer and not a jury. It may be determined as a preliminary question, and proceedings can be dismissed from the outset if it's not established. So in summary, for a defamation proceeding to get off the ground, there needs to be 1, publication, 2, identification, 3, defamatory meaning, and now 4, serious harm. Now, I appreciate I've been speaking at everyone for a little while now, but the next topic I wanted to touch on was the Voller decision. Well, I'll try to keep this snappy because I know it's intertwined with the Defteros decision that Mel will be discussing. So, Voller. Voller is a relatively recent High Court decision involving media companies that each created, operated, and maintained a public Facebook page. Each of the media companies created posts on their Facebook pages hyperlinking to news stories about Voller and his incarceration in juvenile detention in the Northern Territory. Now, third-party Facebook users left comments on these media posts, their Facebook posts, that were alleged to be defamatory. So the question was whether the media companies whose Facebook pages hosted comments by third parties were in fact publishers of the defamatory material. So the Supreme Court ordered that this question of the publication be decided separately. So at first instance and on appeal, it was held that the media companies were publishers of the third-party comments, notwithstanding the technological limitations they had on the control of the pages. However, before the High Court, the media outlets changed their position with respect to intention and knowledge. So essentially, the media outlets tried to contend that the common law required the publication of defamatory material be intentional, which meant that without knowledge of what the third parties were commenting, there was no publication. The bench rejected this and effectively held that publication did not require knowledge of the defamatory matter being communicated or an intention to communicate it. However, their honours differed in their method of assessment of whether media companies had actually participated in the publication. So just at a very high level, the decisions to note come from Kiefel, Keane and Gleeson, who considered that the media companies had facilitated, encouraged and thereby assisted the posting of comments by third-party users, which then rendered them publishers of those comments. Gagler and Gordon similarly emphasised that the media companies had chosen to operate Facebook pages in order to engage commercially with the public, and for the media outlets to assert that they were passive victims of Facebook had an air of unreality. As such, the strong 5-2 majority dismissed the appeals and held that the creation of a public Facebook page and posting content on that page encouraged and facilitated the posting of comments from third parties, which amounted to participation in publication. As such, those operators were liable for the defamatory comments posted by third parties in response to their content. So what are the key takeaways? What are the key takeaways here? Well, in light of the decision, any person or organisation who facilitates an online social media presence for their brand that permits third-party engagement may be held liable for any defamatory material that is published to their page. Businesses should consider the current digital presence carefully, particularly if permission settings on social media permit public engagement without administrative oversight. While the serious harm element will limit the effect of Voller, businesses need to remain vigilant of the high risk of exposure as against the benefits of having engagement in their online spaces. So that's all I've got time for. I'm going to hand back to Paolo, who's going to introduce our next speaker.
Thank you, Amanda. I'm hoping we have a recording of this seminar because I suspect that I'll need to find another lawyer here to help me draft a concerns notice, given you clearly defamed me.
I thought I was so careful.
We'll see. Thanks for that, Amanda. Our next speaker is Melissa Marcus. Melissa has been at the Victorian Bar since 2010, but prior to that had been a solicitor. She practices in intellectual property, commercial, and importantly, defamation. I've personally worked with Melissa on a few defamation matters, including a very high-profile one. She's been involved in a number of very high-profile defamation matters, and I know that she certainly knows her stuff when it comes to this. I'm going to see if she can act for me against Amanda, but she might have a conflict given that we're all presenting together. But if everyone could please welcome Melissa.
Thanks, Paolo. I apologise in advance for having a very raspy cough, although hopefully I'll be better than I was in court last week when I was trying to make submissions and actually couldn't speak. It's rather unfortunate as a barrister. And I just have to, before I start, I was remembering when Amanda talked about the number of, the turnover of Prime Ministers, and I distinctly remember seeing a sign on Facebook when it was November, and a sign outside a hairdressing salon, which I think was in Brighton, which said, "Only 4 more Prime Ministers till Christmas." Anyway, so without further ado, I'm going to talk to you about the August 2022 decision of Google and Defteros. Now, this is a really serious, thank you. This is a very serious, no, that's it. Thank you. This is a significant decision of the High Court concerning the question as to whether a party is a publisher of defamatory matter. Amanda took you through the various elements of defamation. The key one, the first one, is whether you are a publisher. If you don't get over that threshold of establishing that you are a publisher, or if it is found that you are not a publisher, then there is no defamation. You don't even need to think about what defences can apply to what you've written. In Webb and Block, which is 1928 High Court case, which was recently affirmed in Voller, the High Court held that any act of participation, so any act of participation in the communication of defamatory matter by a third party is sufficient to make that party a publisher for the purposes of the law of defamation. So Voller reaffirmed that 1928 High Court decision and basically saying that any act of participation was sufficient to make you a publisher, which is a very, very broad test. Now in Defteros, the High Court had a chance to analyse both of those decisions in detail, together with overseas case law, and there's quite a detailed analysis in Defteros about overseas case law. And the Defteros decision can be seen as an attempt by the High Court, sensibly I would say, to rein in what is meant by publication when considering actions on the internet. And I say that because Voller had the potential to be very, very wide-ranging in terms of who and what acts would constitute publication. So I'll start with an analysis of Webb and Block, which is the 1928 case, because this is and purchases of wheat script in different states. The committees had as their object to seek compensation from the Government of South Australia for the benefit of growers. And to that end, the committees each instituted and controlled various legal proceedings. But a difference of view arose between the committee, of which most of the arose between the South Australian Committee and the Victorian Committee. So the South Australian Committee was chaired by the plaintiff, and the Victorian Committee comprised most of the defendants. And the dispute was about whether litigation controlled by the South Australian Committee should be settled. Now, a solicitor acted for both committees, the South Australian Committee and the Victorian Committee. one of the defendants, Mr. Block, instructed the solicitor, who acted for both committees, to compose a circular that contained information which was untrue and defamatory of Mr. Webb. Mr. Block knew that certain of the contents of the circular were untrue. One of the defendants was not aware of the circular's contents, but he was aware that certain statements in it were untrue, and the other defendants were unaware of either the contents of the circular or whether the statements in it were true or false. But they knew there was a circular, and they knew there was going to be a circular. Now, the majority of the High Court held that all of the defendants were liable for the publication of the defamatory matter in the circular, and the solicitor's malice was attributed to all of the defendants. And Justice Isaac concluded that whilst it might be said that the solicitor was the real author or the mastermind, and the defendants were the intermediate agents to disseminate the libel, it said they cannot employ the mastermind for the very purpose, accept its suggestions, prove and disseminate its production, and then disclaim its malice. So even though a majority of those defendants didn't know what was in the circular, they were all found to be responsible for it. Now, as Amanda's taken you to, in Voller, it was the response of some third-party users to encouragement, which was said that, so the Fairfax was said to have encouraged people to place comments on the Facebook page, on the comments section. And it was the response by those third-party users to that encouragement which contained the defamatory material. But it was the defendants' acts in facilitating, encouraging and assisting in posting of comments by the third-party users which rendered Fairfax liable and the other defendants liable as publishers of those comments. And what's interesting about both Webb and Block and Voller is they didn't involve the actual distribution of the defamatory material. The defendants were involved in and participated in the publication of defamatory material by conduct which preceded its dissemination. So in Webb and Block, the defendants approved the creation of the defamatory material in the circular for the purposes of its distribution. And in Voller, the defendants encouraged the creation of the alleged defamatory matter. In Voller, the defendants additionally were said to have facilitated its publication by providing a platform for its communication. And it was against this background that the High Court in Defteros considered whether Google was a publisher. Now, the facts in Defteros: the respondent, George Defteros, is a solicitor who has practiced criminal law for many years and who has acted for persons who became known during Melbourne's gangland wars, including Mick Gatto and Mario Condello. In 2004, George Defteros and Mr. Condello were charged with conspiracy to murder and incitement to murder Carl Williams and others, and they were committed to stand trial. In 2005, the DPP withdrew the charges against Mr. Defteros. Now, in the intervening period, the prosecution of George Defteros and Mr. Condello were widely reported, including in the Age newspaper, and articles were placed on the Age's website. Skip forward many years, George Defteros was back practicing, and in 2016 he became an internet search using his name on Google. It produced results which included a snippet of an article published by the Age in 2004 on the day after he was charged, and that was referred to as a search result. Now, on the slide, this is what appeared when a search was done on Mr. Defteros' name. There was the title of the article, which was displayed in the search result, and it contained a hyperlink to the full article on the Age's website. So here's the hyperlink to the Age, there's the article, and there's a snippet. The article, entitled "Underworld Loses Valued Friend at Court," referred to as the Underworld article. Together, the search result and the Underworld article was said to comprise the Webb matter. And Mr. Defteros claimed that the Webb matter defamed him. Now, at first instance, in front of Justice Richards, in the Supreme Court of Victoria, Mr. Defteros claimed damages for defamation from the appellant as publisher of the Webb matter. So he sued Google for defamation. Google denied publication, and in the alternative, pleaded the common law and statutory defences of innocent dissemination and qualified privilege. At first instance, Google submitted that it couldn't be liable as a secondary publisher because of course the primary publisher is The Age, but Google said we're not liable as a secondary publisher because Google said its search engine was fully automated and it doesn't intend the communication of any particular words or images, including any third-party web page to which a user might navigate. However, Justice Richards didn't accept that argument. Her Honour found that the Google search engine was not a passive tool. Her Honour found that it was designed by humans who work for Google to operate in the way that it does, and in such a way that it identified objectionable content, and it operated in such a way, that identified objectionable content could be removed by human intervention from search results that display to the user. So Her Honour was influenced by the fact that whilst the Google results throw up a whole raft of options when you search on someone's name, or in this case, Mr. Defteros' name, humans working for Google could remove content. They had the power to remove content. And on that basis, Justice Richards found that Google became a publisher of the search results, that its search engine returned to a user who entered the search query after it was put on notice. So, I mean, that often with these things, you need to put someone like Google on notice. And once they're on notice, they can then no longer claim or rely on the defence of innocent dissemination. So she said once Google had notice, Google was responsible for the publishing as a publisher. Relevantly, for the purposes of the High Court appeal, the primary judge found that Google had published the web matter based on Her Honour's view of the significance of the insertion of the hyperlink to The Age website in the search result. Her Honour concluded that Google publishes the web page that is reached by clicking on a hyperlink within a search result because its provision of a hyperlink search result is instrumental to the communication of the content of the web page to the user. Google appealed to the Court of Appeal and lost, and then appealed to the High Court. In the High Court, the majority judges held that the principles in Web and Block and Voller do not apply to Google search results that are not themselves defamatory or to hyperlinks to defamatory web pages accessible via ordinary Google search results. Now, I'll take you through the judgments of the various judges in the majority, but what is important here is, for instance, this snippet doesn't contain anything that's defamatory. It's just a headline of really what's in the article, but it's nothing about George Defteros that is defamatory. And to access the material, you have to click on the link and then you go through to the Age website. So Chief Justice Keeble and Justice Gleeson wrote in the judgment. They identified that the question which arose here was whether providing search results which, in response to an inquiry, direct the attention of a person to the web page of another and assist them in accessing it amounts to an act of participation in the communication of defamatory matter. Their Honours noted that despite the principles regarding publication of defamatory material having been regarded as having a broad reach, i.e. Voller, this did not mean there were no limits to what actions are captured by the rule or that any connection between a person's act and the publication, however remote, will render them liable as a tortfeasor. Their Honours noted that the publication of the defamatory matter here was best understood as occurring by the communication of the article on the Age's website to the person accessing the web page. The question raised by Web and Block and Voller are whether the appellant could be said to have participated in the communication of the matter contained in the Underworld article. So that's the Underworld article there when you click on that. Whether Google has participated in the communication of the matter contained in the Underworld article or have been instrumental in or contributed to any extent to the publication of that matter. Their Honours found at paragraph 49 that it cannot be said that Google was involved in the communication of the defamatory material. Their Honours stated it did not approve the writing of the defamatory matter for the purpose of publication. It did not contribute to any extent to the publication of the Underworld article on the Age's webpage. It did not provide a forum or place where it could be communicated, nor did it encourage the writing of comment in response to the article, which was likely to contain defamatory matter. Contrary to the finding of the trial judge, the appellant was not instrumental in communicating the Underworld article. It assisted persons searching the web to find certain information and to access it. And then at paragraph 50, Their Honour said, there is a difference between drawing a person's attention to the existence of an article and communicating its content. And whilst it may be said that the use of a hyperlink may mean the Age gains a reader, that does not make the appellant something other than a reference provider. There was no interest in Google having people click on the Age website. They weren't gaining anything from having people click on the Underworld article. At paragraph 53, Their Honour said, the question of whether the appellant could be said to participate comes down to the assistance provided by the hyperlink to move to another web page. Their Honours concluded that a search result is fundamentally a reference to something somewhere else. Facilitating a person's access to the contents of another's web page is not participating in the bilateral process of communicating its content to that person. Justice Gabler agreed with the Chief Justice and Justice Gleeson. Justice Gabler commenced by noting that whether someone is a publisher of defamatory matter communicated by means of the internet is determined in the application of the standard common law principles by the majority in Voller and by reference to Webb and Block. So he starts from the position that Webb and Block and Voller are still the key authorities on publication, but then starts to rein it in. Donna stated that those standard common law principles posit that publication is a process which includes making matter available for comprehension by a third party, relevantly by including the matter on a web page, and which is completed upon a third party having the matter available for comprehension, relevantly viewing the web page. Those principles further posit that a publisher is anyone who is an active and voluntary participant in any part of the process of publication. So the key thing here is being an active and voluntary participant. And the active participation is how Google avoided being found to be a publisher in this case. Justice Gabler agreed with Chief Justice Keefe and Justice Gleeson that Google was not a publisher. His Honour analysed, as did other judges, analysed in detail overseas authority, particularly Canadian authority, and stressed the desirability of consistent approaches throughout the common law world. His Honour stated that the ubiquity of the internet and the centrality of hyperlinks to its operation make consistency in the characterisation of a hyperlink across common law jurisdictions especially desirable. And this is interesting because there was divergence between where Voller was suggesting that Australia would be going in terms of determining who was a publisher and overseas authorities. So the High Court has reined it in, and overseas authorities are clearly relevant and are authorities that we ought to continue monitoring here. Agreeing with the Chief Justice and Justice Gleeson, Justice Gabler also noted that the search result in this case was not a sponsored link, which His Honour said is a form of advertisement created by or at the direction of advertisers willing to pay Google for advertising text which directs users to a website of the advertiser's choosing. So I referred before that the Chief Justice was saying that there was no interest in having people click on the Age's site. It's a bit different where you've got a sponsored link where there is a community of interest between Google and the person who's paying for the sponsored link. Rather, this search was an organic search result generated from the operation of the ranking algorithm of Google, of the Google search engine. No feature of the content of the particular organic search result in the present case was found to have operated as an enticement or encouragement to click on the hyperlink. That is, going back to the slide earlier, which showed what the search result looked like. There was nothing there that was enticing you in a page of organic search results to actually click on that link. Whereas the search result comes up, it's highly ranked, so it's a bit different. At paragraph 73 to 74, His Honour concluded that the critical feature is that the search result is no more than a designedly helpful answer to a user-initiated inquiry as to the existence and location of information on the internet. Of significance was the following. By entering a search term into the Google search engine, the searcher looks for matter on a topic of interest to the searcher. By providing a search result, Google indicates where on the internet that matter may be found. The hyperlink in the search result identifies the web page on which matter on that topic is located. Having obtained the search result, including the hyperlink and the snippet, it's then up to the searcher to decide whether or not to take that further step of clicking on the hyperlink so as to access the web page, in this case, the age web page. And Google does not, merely by providing the search result in a form which includes the hyperlink, direct, entice, or encourage the searcher to click on the hyperlink. There was no extra step by Google. The next two judges in the majority, Justices Edelman and Justice Stewart. Justices Edelman and Stewart drew attention to the fact that they dissented in Voller, but they were in the majority here. They considered that there were three ways that Google could be said to be a publisher. One, based on the system employed by the appellant, by Google. Two, enticement, and three, incorporation. I'm doing the time. In relation to the system employed, they rejected the argument that Google's system made it a publisher. At paragraph 220, their honours concluded that the critical step that results in publication is that of a person searching and clicking on the chosen hyperlink. The role of the appellant rose no higher than a mere facilitator because the appellant had no common intention shared with the age that the searcher click on the hyperlink to the Underworld article. It wasn't enticing you or encouraging you to click on that link in the page of organic search results. Their Honour said that Google in no way participated in the vital step of publication, without which there could be no communication of defamatory material, namely the searcher's decision to click on the hyperlink of a particular result. So they weren't satisfied that Google's system itself would make them a publisher. The second way that they said that a party could be a publisher was enticement. So Google could have been a publisher of the Underworld article if the search result enticed the searcher somehow to click on the hyperlink contained within it. Their Honours accepted that if search result by its content was likely to entice the searcher to choose a given third-party web page over others, then an inference might be drawn that the assistance in the search was given with a common intention shared with the third party in the sense of a concerted action to a common end. But again, these are just organic search results. You can click on whatever you want off the page, and Google was doing nothing to encourage you to click on that site. So the evidentiary foundation for enticement here was established. The words that accompanied the search result simply describe a story about a criminal lawyer and his clients and no more. So again, when I showed you what the hyperlink and the search result looked like, there were two lines at the bottom. That didn't have anything in it that enticed you to click on that hyperlink. The third way their Honours said that Google could have been found to be a publisher was via incorporation. And incorporation came up in a South Australian case involving Dr. Duffy, where the snippets, so the two lines at the bottom of the search result here, where snippets in the Duffy case actually contained defamatory statements. And again, that's different because that is the repetition of the defamatory statement. And in that case, the Chief Justice in South Australia said that constituted incorporation of the material, and therefore Google in that case was a publisher. So it was an interesting analysis by their Honours about how you could be found liable, but in this situation, facts weren't made out. Justices Keane and Gordon both dissented, each considering that the case was resolved by an application of the principles in Webb and Block and Voller. Basically, their Honours said Voller was so broad-ranging in its impact that it covered what Google did. So they were of the view that Google ought to have been liable, but as I said, they were in the majority. Now, the outcome of the case shifts the common law of Australia in line with jurisdictions such as Canada, England and Wales. And that's important. And does mean that we can keep an eye on overseas authorities, and we've been brought back into line, which is a relief. But the outcome of the case is no doubt a relief for companies, search engines like Google. However, search engines like Google and small players, and I'm sure Paolo will go into more detail about this, they can still be found liable as publishers where, for example, sponsored links are involved, or where the facts of the case otherwise sit between Voller, where there was clear and obvious enticement, and the facts in Google, where you've got organic search results where there wasn't an enticement to actually click on that search result. And looking at the examples given by Gabler, Edelman and Stewart, there you can see some ways that search engine operators or businesses in general that include material on their web pages could be found liable as publishers. It could be where the system employed is such that it makes you a publisher. Now, Google did not acquire a finite number of web pages. That's what their honours found. The search results threw up an untold number, an infinite number of web pages. So it wasn't a finite number. Google wasn't sitting and having people sitting in the office vetting the web pages. It was like opening up Pandora's box, the whole wide web. The situation could be different if you operate a system whereby you do offer a finite number of search results. That could change the state of play. Google had no sensible means of vetting the contents of its pages because it was just the world at large, the internet at large. But the situation may be different if you have a system that does allow you more easily to vet the content of your search results. So there are ways you could see that a system could make you responsible as a publisher. Enticement is something that comes up through and through in this case. In Voller, it was found that the provision of the ability to post the comments online was an enticement, an encouragement of people to post those comments, and therefore, in that case, the defendant was responsible for the defamatory comments that were posted. Here it was said, these are just organic search results, there's no enticement of people to actually click on this result. But sponsored links is a different situation, because with the case of sponsored links, as I've mentioned, there is a consistency and there's an alignment between Google and the party who's paying Google for the sponsored link. That can be seen as an enticement. That link comes up, as you know, you type in, a search on Google, you'll get your organic search results, and then you'll get your sponsored links up top or down the side. That's an encouragement for you to click on those sponsored links. So that's a different situation. If the defamatory material is in a sponsored link, that is going to be likely to be seen as being an encouragement or an enticement. And the other way, of course, is incorporation, where there's a reproduction of the defamatory material in the snippet provided. So if what appears on the Google search page itself is defamatory, Google or any third-party organisation reproducing defamatory material will be found to be liable as a publisher once they have noticed that it is on there. So in conclusion, despite the Defteros decision, companies must remain cautious linking to material on other websites. The context in which hyperlinks are provided will still render the company liable as a publisher of defamatory material. If a search result or hyperlink contains material which would direct, entice or encourage someone to click on the link, the company providing such a link may be deemed to be a publisher of that underlying material.
Thank you very much for that, Mel. So, what does this all actually mean? What does this mean in particular for small businesses? What does it potentially mean for a sole trader? One thing that we haven't really touched on today, and I'll just flag at the outset, is to be aware that in terms of defamation, a company will not have a right to bring that action unless it's regarded as a business which employs fewer than 10 employees. There are other options available, but in general, that's just something to be aware of from the outset. What these advancements in the law really show is what I call the double-edged sword. The first is that as business owners, who have a social media presence. I'm sure you've got Facebook pages, you've got Instagram pages, you might even have TikTok pages. You've got pages where you try and engage and interact with the community, your consumers. Because of the prevalence of trolls, other people who can go and post on other pages, it's no longer the case that you're limited to go after that troll. So customer A comes onto one of your competitors' websites and slags out your business. You now have the ability to go after the person behind that page. It's no longer just the person who is posting it that is responsible for it. It's the person who controls that page. And that's great, because as a business, as an individual, as someone who considers their reputation sacred, it's important to have those options. It may be that you can't identify the person who posted, who made that post. That's always a really significant issue, particularly in the online day and age. Anyone can create an email address. You know, are you really going to go to the expense of trying to find out, you know, who that person is? Will the company, if it's a Facebook post, give you access to information about IP addresses or who's behind it? Maybe, maybe not. So it's given us more power to write to the administrator of the page, to your competitor, potentially to Facebook itself, and try and get a resolution. And certainly, given, you know, cases like Voller, we expect that people like Facebook, like people, you know, the ultimate source, will take these complaints more seriously. I can tell you for many years, you could write a letter to Facebook or Google and say someone's posted something, and if you got a response, it was usually to piss off. But in this day and age, it's taken a lot more seriously because they now know they're responsible. But with that benefit comes a significant detriment, and that is that you yourself are probably running a Facebook page for your own business. And you are now responsible, potentially, for what people are posting on your page. And take this as an example. Joe Smith comes along to your page and posts a fantastic review, raving about your services. And then at the end decides, so much better than their competitor, Jane Doe. Well, what do you need to do? Are you now responsible for that, assuming that, you know, say that the comment actually, you know, was defamatory? Absolutely, you're responsible for that. So whilst you have the power to go after these additional people that once we couldn't go after and actually get a post taken down, potentially get some vindication if you do want to take defamation proceedings against a competitor, you yourself can be on the receiving end of it. And as Mel discussed, with the Google case, with the Defteros case, although Google was not found responsible for the hyperlink, what if one of your customers posts on your social media page, go and check out all of these poor Google, you know, reviews left on, you know, Google about a competitor, and they post a link to that, which contains a raft of defamatory material? Would you yourself be responsible? Google wasn't, but have you been involved in that? Have you enticed people to come along? There's a whole raft of issues that are now left unsettled by these two cases. And so more and more as businesses, it's not only a matter of now having the power to take additional steps to protect your reputation and your stake in the space in which you operate, but ensuring that people who interact with you are not making you indirectly liable for things that they might say, things that they might think about other people. So time will only tell how far this goes. As Mel has told us, Defteros has tried to rein in Voller a little bit, but it's still left a number of questions out there. What is the extent to involvement? What is the extent to which a small business needs to take steps to control what other people are posting on their page? One thing that might happen is the stage 2 review of the model defamation provisions, which I think submissions closed in early September, and so they're currently under consideration. Now, it may be that these reforms will provide some guidance to businesses and individuals alike. They're considering things such as exemptions for intermediaries, so people who are described as mere conduits of information, much like, you know, as Melissa's discussed with Google, where it was just a conduit. It didn't actually turn its mind to anything, organic results popped up. If you're using something like, Google AdWords or banners on your website where you're not necessarily in control of the content that's popping up, are you responsible for that hyperlink, given that you're paying for a service and that is appearing on your website and third-party users are able to comment on that? Or will you be just a mere conduit and therefore within an exemption? We'll see what the reforms might tell us. There may also be further defences that are added or broadened, including innocent dissemination, which Mel touched on, and other things. So we really need to wait for those reforms to come in to see whether or not they do or don't provide some further clarity. And potentially we need to wait for the next High Court decision to tell us a little bit more about who is and who isn't responsible or where that line actually is. There's also some changes, anti-trolling legislation has been introduced by the federal government twice and not passed. They've tried to sort of limit social media involvement, deeming people who are administrators of social media to not be publishers. That hasn't passed. It hasn't passed twice now, I think. Is that right, Mel? Yeah, 2021 or 2022. It may come in and resolve this entire question. We don't know. So what we really think you should be taking away from today is defamation is moving rapidly at the moment. And that's not surprising given the day and age of technology, although it's perhaps surprising that it's only happening now and probably not 5 years ago. But we really need to watch this space. But in the meantime, you do need to take steps to protect your reputation. And that means you should be looking at your competitors' social media. You should be looking at what people are posting. You should be looking at Google reviews. You need to be looking at all these things and be vigilant. And where somebody has said something about you that you consider defamatory, get advice, take action. Don't allow that to stand. 5 years ago, we might have said, you're not going to write to Facebook, it's a waste of time, you're not going to take them on. These days, the view is very different. They may well take it seriously and take it down for you. The second thing that you need to remember is that you may now be caught in the crossfire. So not only should you be spending time looking at what your online reputation is and what people are posting about you online, but you need to be looking at what you control on the internet and what people are posting about others, because otherwise you may very well be the next High Court case where we need to decide, where that line is. So that's all I really had to say for today. We do have a little bit of time if anyone here or online, there's a little Q&A function. If anyone's got any questions of either myself, Amanda or Melissa, we'd be happy to take 1 or 2 questions now. Otherwise, for those of you that are here, we'll be around for a few minutes if you wanted to have a chat.
Got a question, Paolo. Melissa, a bit off point, but what was physically the age article? I mean, talk about publication or link to the age article.
Well,
I assume it's defamatory itself, was it?
yes, yeah, because the situation had changed subsequent to the age article.
It's a timing thing.
But it was a time, but it was a statute barred. So the age article was published in
But if
2000.
it's the age website,
But it was published in 2004.
so it's the
So looking at it in 2016, they were looking at the link to the age. That's why they were going after Google, because Google had provided they were trying to say this is a new publication by you, linking to it. So they
Follow up to that one. So what about if Paolo's written to Amanda and Amanda's taken down her article about King Street, but Google keeps that link up there with the metadata on it?
Well, but that's exactly, if they're not enticing you and it's just an organic search result, then it's the Defteros decision would apply.
So even if Amanda's taken the article out of the website.
Yeah, so because if it's still out there in the internet. I mean, although if Amanda's taken it down, that's the original source that you would be linking to, you probably wouldn't be able to get to it. It wouldn't come up.
No, we'll give you a follow. It can still come up in Google.
But if there's nothing defamatory in the organic search result that comes up, so the snippet itself is not, it's just a headline of the article, then there's nothing. But if they reproduce something in the snippet that is defamatory, then that becomes incorporation, which is what Edelman and Stewart said, that could be a way that you are caught as a publisher.
And a really interesting issue on that is some people might be aware of like internet archive searches, like the Wayback Internet Machine and things like that, which go through an image, websites and articles. Nothing is deleted forever. Now, if Amanda's article about me got taken down, but the Internet Wayback Search took an image of it and could be accessed, are they liable?
I haven't looked at that.
It's an interesting question based on Defteros, for example.
Sometimes though, with Wayback, you click on it and it's meant to have an image, but you'll get an error message. So something's come down.
But are they an innocent, are they like Google, which is just an organic search? Or is the fact that they've taken an image had an active role in it? Does that make a difference?
Personally, I would think the High Court would be more likely to treat them like a Google in the Defteros sense.
Well, perhaps we'll find that case file and we'll try it out. One more question if anyone's got one. Any online, Andrew?
No.
Oh, yes?
Oh, sorry. I'd just like to ask if the company or company being attacked is a significant organisation, how would you define significant harm to them to be able to bring successful action against the person that defamed them?
It would be financial? Yeah, it's likely to suffer. I mean, if it's a significant organisation in terms of size, it's not going to be able to sue anyway for defamation because it won't be an excluded corporation. So that it would have to then sue for injurious falsehood. But if it's a smaller organisation, it's a financial question. Like, is it what the significant harm change has sought to do is stop the courts being clogged up with gripe matches.
Yes.
Where somebody's written something on Facebook about someone else, 5 people have read it, it's been taken down, it was up for 3 days, it's going to sound in damages maybe $10,000. That's not significant harm.
Yes.
That's not going to damage you. What and it's adopted this based on the UK approach is leave defamation for really serious stuff where people's reputations really are significantly damaged. So it is looking at, the courts are looking at, is this going to sound in substantial damages?
Thank you.
No problem.
Thank you very much, everyone. I believe we have our next breakfast seminar on the 17th of November. It will be an employment law update. And one of our speakers will be Brie Calhoun, who's just joined Aitken Partners. So please come along to that if you're interested in getting an update on what's going on in the employment space. Otherwise, thank you again for coming. Good to see you all again. Thank you for coming online, and we'll see you at the next one.